And it's because you have to really explain what it means, or you're stuck with what everybody else brings to the term itself, and it may have a tribal meaning to folks. So some people could take it as, gee, she will vote for her tribe, and that's, let's put her tribe on the Supreme Court. That's a toxic version of it, and that's why I use the sentence from Justice O'Connor, which is my meaning, but I wouldn't say it's my meaning of that term, but it's my meaning, that it really matters that we have people who, in fact, are educated through broad exposure. When I was preparing, let me give you just, this is a 1-minute little story. When I was trying to figure out how best to defend Michigan and defend its policy for diversity, I went and I actually sat down and interviewed all of the senior faculty on the Michigan Law School. And there are some members who are who have been there for a long time, who had taught when there were no or insignificant women in their classes, and who now taught, or then taught, when there were very substantial numbers of women. And I went and asked them about that because it's easier to talk about gender than it is about race. And I said, what happened in your classrooms when significant numbers of women came in? And I talked to someone who is quite well known, and he teaches property and property type courses, secure transactions and property. And he said, something remarkable happened and I didn't actually expect it. I'm very conservative. But when women came into my property class, things we never used to talk about came up. I didn't fully appreciate how much of property is about gender. I didn't understand that some things that routinely used to come up no longer came up. And we had a much better class discussion for all of the students than we had before. I then say, well, what happened when you had a group of, black students and Latino students in your class? He says, something very similar, but I wasn't in as much doubt about that as I was about women and what it would do in my class. And my point is, that's the example of he came out of his own class and his students came out of that class with a very different appreciation for what they now knew and even what they knew they didn't fully appreciate. And that's what I would say Justice O'Connor is talking about when she is talking about the value of that classroom for our leaders, for our judges, for our justices. But I wouldn't use the term empathy because it can be hijacked by your own personal, whatever your baggage is for that. So the anecdote encompasses what I'm talking about, and the sentence I used from Justice O'Connor encompasses it.
I think it's a function of, I think we will soon be able to use it, or use a term like it. I think what's happened over the past 30 years is that each side has been guilty of a kind of reductionism. Mostly Republicans, but what I'll call judicial minimalists, have argued that that law is essentially a syllogism machine, and that what you need to do is find the external legal rule, plug in the external facts, and the machine takes care of itself, and anything beyond that is illegitimate judging. And they therefore would say that empathy is terrible because it doesn't matter who it is that's running the machine is fundamentally mechanical. And only if the only way empathy could work in a situation like that is to cheat in using the machine, and that would be terrible. So that's been one side of the debate. The other side of the debate has been people who've argued that law is essentially almost entirely the kind of thing that the judge can make up as the judge goes along, simply postulating retrospective explanations for a decision that essentially gets made in the judge's political gut. And that law is essentially no different than any other kind of politics that's just carried on by men and women wearing black robes. And for them, empathy would be hugely important because empathy was all there was. And I think the good thing that's happened in the last couple of years has been the recognition by both sides that the other side has something to the argument, and that a good judge does both. A good judge suppresses empathy if it means that they can't really find the external sources that binds them, but lets the empathy go once they're beyond that machine. And once we come, I think, to an understanding that that's the model that we're using, people won't be ashamed to acknowledge that their life experience is playing a role in their judgments about what the consequences of particular decisions are.
I'm afraid I have to disagree. The only thing that you said, Burt, that I disagreed with, so of course that's the thing I'll seize on. If empathy is to play a role, and I think that the introduction of the term was politically disastrous and should not have occurred, advice should have been given at some point. I was available. If empathy means something positive, that is, in the sense that you aggressively exercise it, I'm against it, for precisely the reasons that have already been given, because it cannot be exercised without moving in the direction of one party or interest or the other. If empathy means something like a set of interests and commitments within which you begin, and a set of interests and commitments that are in fact guiding your understanding of what Burt has referred to as the constraints, then it's fine, and it's also harmless. All it means is that you, like and I and everyone else, comes to any activity with a set of assumptions about the way the world is and a set of desires about the way the world should be. And although these are not explicitly invoked and should not be, they are nevertheless guiding the way in which we see our tasks, even, as I've already said, a task that is chock full of constraints. So that I think that by bringing empathy into the conversation in a political context, it's almost inevitable that people are going to be thinking about empathy as something that you add on at the end of a process, where I believe it's simply the name for the interests you come in with, and I don't believe that there's any one of us who could come into any situation without interests.
Yep.
Let me just raise, Stanley and I are in virtual total agreement on a lot of that, which should make all the rest of you very nervous. But my sense is that, let me raise one thing. Most of you have heard about the Lilly Ledbetter case, which was a case that was decided by the Roberts Court, and it dealt with what the statute of limitations is on bringing a claim for gender discrimination in pay. And this woman had worked for this company for many years and had been disgracefully underpaid during the whole period because of a policy of paying women less than men for doing the same job. Now, she didn't learn about this policy until just before she retired. And I'm going to get, I forgot how many years. Let's assume she'd worked there for 25 years. And she didn't learn about this policy until just before she retired, when she found out about it, and she filed a lawsuit. Now, the text of the statute is terribly badly written. It's a horrible exercise in draftsmanship, but it indicates that you're supposed to bring the lawsuit within a year of the discrimination, which makes good sense. You don't want to let these things hang out forever. And the question is, when did you measure the year from? Did you measure the year from the time that she learned about the discrimination, or did you measure the year from the time that the discrimination started? That's where empathy plays a role. If you've never lived in the shoes of a woman working in a male company, then you don't know that one of the worst things that she can do is appear to be looking at what other people make, trying to be a troublemaker, trying to figure out whether she's getting her fair share. There is no sure way of ending a career for a woman in a male job than to appear to be a troublemaker over compensation. And Lilly Ledbetter didn't look. She didn't look. She lived her life, and the Supreme Court held that she should have looked. that there was a 1-year statute of limitations, and that 1-year statute of limitations had run out. It's at that point that empathy, and I think that's what Obama was talking about when he was talking about empathy. A judge, to decide that case, could have gone either way. The text went either way. The legislative